Namaste, good morning. Welcome to 136th episode of AAA Weekly Webinar Series. Today, the episode is being conducted by me alone. My colleague Ankit Goel is not available today, but presently he is in flight. So the time of the flight, in fact, clashed with the time of this episode. The entire profession is talking about the liquidation order of Jet Airways. Therefore, we decided that we will conduct a detailed webinar on the in-depth analysis of the Jet Airways judgment. In fact, Jet Airways has given lot many judgments to IBC. We would be actually conducting another webinar where we will deliberate on all the judgments which has been delivered by Honorable Supreme Court or confirmed by Honorable Supreme Court and delivered by NCLAT. That is very important to understand that a company, Jet Airways, has added a lot of litigation and a lot of clarifications also. About 4 or 5 appeals have gone to Honorable Supreme Court in the case of Jet Airways. This is such a resolution where 5 extensions were given for implementing. 5 extensions were given for implementing. So therefore, there are, in fact, in the judgment that we are deliberating today, there were 5 issues raised by State Bank of India, the applicant before the Honorable Supreme Court. Like in today's agenda, we would actually handle the in-depth analysis of Jet Airways judgment, the examination of questions of law dealt by Honorable Supreme Court, the name of the judgment, the citation of the judgment is State Bank of India and others versus the consortium of Mr. Murari Lal Jalan and Mr. Florian Pritch and others. So the resolution applicant. One is the creditor, the lead creditor, that is State Bank of India, and the others are the respondents are the resolution applicant, who actually can be considered also a successful resolution applicant. The judgment was delivered on 7th of November 2024, and in this judgment, the Honorable Supreme Court, in brief, actually clarified few issues. One issue was that the performance bank guarantee, which is given after the approval of the resolution plan by the Committee of Creditors and before it is submitted to the adjudicating authority for approval, that is a kind of performance security which was given in this case as performance bank guarantee of about 150 crores to the creditors, and that was in fact whether that should have been adjusted with the first tranche of payment or not. That was the first issue which was raised by State Bank of India, and Honorable Supreme Court clarified it. Then the Supreme Court also says that whether the non-implementation of resolution plan by successful resolution applicant necessarily lead to the consequences of liquidation as under Section 33, subsection 3 of IBC. Now the next question, whether timely implementation of the resolution plan is also one of the objectives of the IBC. Then the Supreme Court also deliberated on whether the Supreme Court can invoke its plenary jurisdiction under Article 142 of the Constitution of India to direct the corporate debtor into liquidation, even though even though the COC has not voted for liquidation, even though the COC has not voted for liquidation. Now, when we see this implication and impact of the judgment on IBC, in fact, there are many clarifications. Today, we are only handling the clarification given by this judgment dated 7th of November 2024, which is State Bank of India versus the successful resolution applicant. In the next webinar, we are also going to deliberate all those judgments which has been given in the case of Jet Airways, where the Supreme Court has clarified various issues regarding IBC, regarding Provident Fund, regarding gratuity, regarding the workman payment, whether the workman should be paid only because they are on roll or not, whether a conditional resolution plan can be accepted by the committee of creditor, whether it violates the IBC. So there are many issues which have been decided by Jet Airways. So this particular judgment that we are talking about today is 7th November 2024, and the court decision says, finally, what was held by the Honorable Supreme Court, that the invoking section 142 and directing the liquidation, that underscores the paramount importance of timely resolution of the cases under IBC. The court also says that this particular case, the entire fiasco of Jet Airways, is an eye opener towards various shortcomings in the code and the functionings of NCLT and NCLAT. And in this particular judgment, the court has also given some suggestions to improve IBC. At last, when Justice Chandrachud was retiring from the Honorable Supreme Court from the position of Chief Justice of India, he observed some of the shortcomings and also gave some suggestions to improve IBC. It is also somehow which is held, timely liquidation is preferred over long drawn resolution or kind of endless resolution. Therefore, the court says timely liquidation will save the value for the creditors. Honorable Supreme Court also reaffirmed that once a resolution plan is approved by the Committee of Creditors and submitted to adjudicating authority, it cannot be modified or withdrawn. It cannot be modified or withdrawn. The judgment also offers valuable recommendations for bolstering the IBC framework, particularly concerning the often overlooked implementation phase. In fact, the Honorable Supreme Court has also said that there should be a kind of oversight committee which looks after the implementation of the various resolution plans. And also, the monitoring committee should have been given a kind of statutory position in the law. Presently, there is no position of monitoring committee. There is no powers of the monitoring committee as per the IBC. However, whatever powers that we draw from the order of NCLT, while the NCLT is appointing a monitoring committee for monitoring of the resolution plan. So this is also very important that the court, Honorable Supreme Court, suggest statutorily mandating of the and formation of the monitoring committee post resolution plan approval, aiming to facilitate a smoother handover of the corporate debtor to the successful resolution applicant and ensure continuous oversight. When we see the impact of this judgment on various stakeholders, let us talk about stakeholder to stakeholder. Let us talk about first for successful resolution applicants. Now, the court says and reinforces the obligation of SRA, successful resolution applicant is under obligation to meticulously adhere to the approved resolution plans, terms, including timelines, and emphasize their responsibility to act in good faith and to revive the corporate debtor. That kind of good faith is expected from SRA. No, what exactly it impacts, or what kind of uh, lesson the lenders can even derive from this judgment? The lenders can say that it is important for all of them to take a collaborative decision. They should work in a collaborative approach during implementation, working in tandem with the successful resolution applicant to support the rehabilitation of the corporate debtor. Then for the adjudicating authority, what lesson the Supreme Court is trying to convey through this judgment? That lesson is that prioritize timely hearing. Prioritize timely hearing and resolutions. Refrain from unnecessary extensions and uphold the IBC's principles without acting as mere rubber stamping bodies. Now, the various impacts on different stakeholders by this judgment, we should actually now come to the detailed facts. We should now come to the detailed facts of this case. As you all know, like maybe Jet Airways, it was a kind of a very, very key player in the airline industry in India. The CIRP started in this case on 20th of June 2019. 20th of June 2019, in case we calculate 2021, 22, 23, 24, and we are presently 5.5 years. 5.5 years of resolution, and after 5.5 years, the resolution plan is now kind of failed, and the liquidation of the corporate debtor has already been ordered by the Honorable Supreme Court. A total claim of 7,800 from the creditors, and the resolution plan was approved. Resolution plan was approved in June 21. June 21, the resolution plan was approved. So in case we see, this is a resolution, the entire resolution CIRP period was 3 years. But once the resolution plan is approved, then the role of the monitoring committee comes. But the resolution plan was approved in June 21. The CIRP, in fact, started in June 2019. So 2021, 20, so in fact, two years. The entire resolution process was 2 years, not 3 years. However, after this, the monitoring has taken 3.5 years. During monitoring, rather the objections on the resolution plan approval, that has taken a lot of time. All this litigation has happened even during the implementation. Rather, the various stakeholders, they actually did not allow the resolution plan to be implemented. And at times, we also feel that the successful resolution applicant was also not very aggressive in getting it implemented. The SRA was also going very cautious, and they were very, very apprehensive whether they will be able to do business or not, whether the AOC would be granted to them or not. That was also a very big issue before them. In the meantime, performance bank guarantee of rupees 150 crore was given, and the RFRP, in fact, the dispute in this particular judgment dated 7th of November 2024 primarily was on the performance bank guarantee. So related to performance bank guarantee, we have taken out the features of RFRP. Features of RFRP, which is the request for resolution plan, the features are very important. One, the first feature was that the SRA must provide an unconditional and irrevocable performance security, either as a performance bank guarantee or demand draft from a compliant bank in favor of SBI within 7 days of being declared as SRA. Next, this amount of 150 crore or 10% of the upfront payment as per the resolution plan, whichever is higher. So it was 150 crore. The performance security will be returned within 7 business days upon full completion of the resolution plan. it cannot be used as set off as part of the consideration offered for the company, regardless of any such indication by the resolution applicant in the resolution plan. So these were various RFRP conditions, and a resolution plan was stipulated. A resolution plan was submitted. Now, in the resolution plan, the 475 crore payment was stipulated towards the CIRP cost and employees' dues. 475 crore was provided in the resolution plan as CIRP cost and employee dues. Then a staggered payment of two financial creditors to the extent of 350 crore, and the first tranche was due within 180 days from the effective date. Within 180 days from the effective date. So the first dispute, in fact, after the resolution plan was approved, first dispute started. What is the effective date in this case? Because from the effective date, 100 days will start, and SRA is looking for extensions, looking for assurances, looking for all kind of renewals and licenses, so that the business is kind of startable. So therefore, the effective date, first effort was made by SRA to defer the effective date, and in fact, I got in a good order from the NCLAT also in that case. So it was also, resolution plan also in fact provided that the resolution applicant will give a mortgage of properties, three properties which are in Dubai, and that particular uh, 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 properties collateral security and bank guarantee of 150 crore. These were the two conditions when this resolution plan was approved, and then therefore the defined effective date as the date of fulfillment of all the conditions precedent. Now, this is the first resolution plan where conditions precedent was accepted by the committee of creditors and also by the adjudicating authority. Conditions precedent, that this was a conditional resolution plan, and in case the conditions precedent are not met, then the successful resolution applicant had the liberty to not implement the resolution plan. So this was the resolution plan where the court even said, yes, conditional resolution plan is also acceptable. Now, in this case, let us try to understand what are the conditions precedent. Conditions precedent, in fact, 5 conditions precedent, and also including various approvals and licenses. So it included one condition, that air operator certificate, which is called AOC. Air operator certificate is required, and unless it actually gets the air operator certificate, the effective date would not be considered. And fulfilling the other aviation regulatory conditions to recommence operations. So one is the AOC, and the other conditions are regarding the aviation regulatory authorities, so that the airlines can recommence operations. Recommencing operations or recommenceable, that is the first precondition precedent. Also, the while approving the plan, the adjudicating authority granted 90 days to fulfill all the conditions precedent. That was the directions given by the adjudicating authority. Successful resolution applicant claimed to have achieved the effective date on 20th of May 22, as against the approved resolution plan, which was on 22nd of June 21. So, in fact, it was almost 12 months. So, the first 2 years, the resolution plan approval from COC and the Committee of Creditors. Then 1 year from the in kind of fulfilling the conditions precedent. So therefore, now we are now at somewhere in May 22. From May 22 till this November 24, the resolution plan still could not be implemented. Even the effective date was achieved in May 22. All the licenses were renewed, the AOC was renewed, that was even as per the company, as per the SRA, it was May 22. It was May 22. Now the first dispute was between the successful resolution applicant and the lenders regarding the fulfillment of the conditions precedent and the calculation of 180 days from the first tranche. SRA filed an application before adjudicating authority seeking necessary directions for the implementation of the resolution plan and a declaration that all the conditions precedent have been fulfilled. Adjudicating authority, in fact, passed the first order in this case based on for this dispute on 13th of January 2023, held that the conditions precedent have been duly complied with, and this date, which is claimed by the SRA, that is 20th of May 2022, that is the effective date. So now from May 22, within 180 days, the first tranche has to be paid. Within this first tranche has to be paid. So that is where now let us see what is the next dispute. Now, once this particular effective date was approved by the adjudicating authority, the appeal was filed by State Bank of India. First appeal was filed by the State Bank of India against this order because the State Bank of India was not convinced that the effective date would be 20th of May 2022. Because I said, in case we consider 20th May 2022 as the effective date, then the SRA would have paid 350 crores within 180 days, and the due date was 16th of November 2022. 16th of November 2022. This was the first extension that was actually granted to this implementation. Because of this was granted only because of the conditions precedent and the definition of effective date, and the effective date was claimed as 20th of May 2022. It was accepted by the adjudicating authority as 20th of May 2022, but State Bank of India filed the first appeal challenging this order. And in fact, the in State Bank of India sought a stay. NCLT declined to stay, observing that the steps regarding the implementation of the resolution plan have to be taken by SRA, which needs to be overseen by the monitoring committee. So there is no stay which was granted. And once the stay was not granted, the State Bank of India filed the first appeal before the Honorable Supreme Court that the effective date has not been correctly uh, approved by the adjudicating authorities. Two, that the NCLAT has not given stay on this particular order of adjudicating authority. Now, the Supreme Court, in fact, what the Supreme Court does in this case, the Supreme Court, when the State Bank of India challenged that order of NCLAT, where the NCLAT declined to give a stay, in the meantime, the successful resolution applicant filed an application before NCLAT seeking exclusion of time and seeking to restrain SBI from encashing the performance bank guarantee and earnest money deposit. Therefore, while the Supreme Court matter was pending, NCLAT, based on that application by SRA, granted an exclusion of 107 days from the calculation of 180 days for infusion of the first tranche of the funds under the resolution plan, and also held that the appellant could invoke the PBG only with the leave of the NCLT. So the PBG, performance bank guarantee, could be only invoked only with the leave of NCLT, effectively extended the period to infuse 350 crores under the first tranche till 31st of August 23, till 31st of August 23. So this was the second extension given to SRA in this fiasco. First was given, and now the second. Now the due date is 31st of August 2023, and again in this particular order of NCLT was also challenged by State Bank of India before Honorable Supreme Court, and SBI filed an appeal, and that for against the second extension order. Now SRA in the meantime filed an application seeking permission to discharge gratuity claims of the installments and to appeal or negotiate a reduction of rupees 24 crores in damages imposed by EPFO on the corporate debtor. In the meantime, the Office of the Director General of Civil Aviation, Government of India, extended Jet Airways AOC, Air Operator Certificate, until 3rd of September 2023. Now, let us see. 31st August 23 is the extended date for payment to creditors. The AOC has actually been extended only up to 3rd of September 2023. So there is only a gap of 3 days. 31st August payment date, and the extension is only up to 3rd of September 2023, limited the completing SCIRP, and with conditions, recertification, applicable fee, and revival action plan post takeover by the SRA. So when this Director General of Civil Aviation, when this AOC was renewed, there were some conditions imposed by DGCA. DGCA imposed certain conditions, and those conditions were like a recertification of certain equipment, some applicable fee, and also revival action plan post takeover by SRA. That was all the conditions which were mentioned by the DGCA in the Air Operator Certificate. Now, while the appeals were pending before Supreme Court, SBI filed an affidavit offering a conditional agreement. If SRA infuses 350 crore by 31st of August 2023, meets payment obligation to employees and complies with the resolution plan terms, the lenders will withdraw their appeal pending before NCLAT and Supreme Court. That was what was mentioned before State Bank of India by way of an affidavit, which was a conditional agreement. One condition, that 350 crore is given by 31st of August 23. Second condition, payment obligation of employees to be met. Third condition, complies with the resolution plan terms, other terms. Now, in this case, now the other terms are, because in the resolution plan, it was also mentioned that the successful resolution applicant will make payment of all kind of applicable fees for the renewal of AOC, Air Operator Certificate. Now, the State Bank of India says that I can withdraw my NCLAT appeal, my Supreme Court appeals, in case 350 crore is infused. 350 crore is infused by SRA on 31st of August 23. All the payment to employees are given, payment of provident fund and payment of gratuity is given. And then other resolution plan terms like the payment of the applicable fee of DGCA is also given, and they will not contest the extension of time or compliance with the conditions precedent of the resolution applicant. That was final decision of the State Bank of India. However, the successful resolution applicant failed in any of these conditions. One, that it failed to pay 350, infuse 350 crore up till 31st of August 23, and therefore the lenders request that the corporate debtor be directed into liquidation. This proposal was made as a one-time opportunity for successful resolution applicant to resolve the matter outside the uh, litigation and to avoid liquidation of the company. Successful resolution applicant then gave a response to the State Bank of India affidavit. State Bank of India affidavit, what it said: infusion of 350 crore, payment to employees regarding provident fund and gratuity, payment of the AOC terms and conditions, renewal fee, and everything. Now, what SRA proposes by way of an affidavit, and SRA says that uh, one, the directions to adjust performance bank guarantee of 150 crore as part of the payment of first tranche under the resolution plan, and permit an infusion of 200 crore as share application money in two installments by 31st August and 30th of September 2023. This was the proposed resolution by SRA. So State Bank of India was saying 350 crore infusion. SRA said 150 crore should be adjusted out of the performance bank guarantee, and the 200 crore can also be added as the share application money. Additionally, the successful resolution applicant, in fact, requested that if the gratuity application was not approved, then the resolution plan should not proceed with a refund of all infused amounts, including the performance bank guarantee. Whereas in this case, the resolution applicant, the successful resolution applicant was also uh, fighting to reduce the obligation of gratuity. And the SRA said that if my gratuity application for a reduction of my gratuity liability is not accepted, then the resolution plan will not proceed further for implementation, and all the money that I have invested should be refunded to me. Now, NCLAT on this particular order on 28th of August 2023 partly granted the adjustment application allowing the performance bank guarantee and extension of the resolution plan implementation deadline up to 30th of September 23. That was the third implementation extension granted in this case, third. So third implementation has also been seen. So now the State Bank of India filed third appeal before Honorable Supreme Court, and in this particular appeal, the State Bank of India again contested the order passed by NCLT, where the third extension was given, and also the adjustment of 150 crore of performance bank guarantee was allowed to Jet Airways. In fact, technically, in case you see, factually, the NCLAT and NCLT has given many chances, many kind of relaxation to SRA to the resolution plan. Various relaxation was given, although State Bank of India was contesting all the relaxation, all the extensions, but all the appeals were pending before Honorable Supreme Court. In fact, 1, 2, and 3, three appeals are now pending, and we are already somewhere in 23. And third implementation extension has already been granted. And in the meantime, the 3rd September 23 is lapsed, and the DGCA's conditional AOC, DGCA's conditional AOC. So what is Air Operator Certificate? It was conditional on three things: one, of the recertification of the equipment; two, payment of fee; and four, other terms and conditions. So these are conditions. So in the meantime, none of the conditions were satisfied. So therefore, on 3rd of September 2023, that conditional AOC in fact also ended. Now, but successful resolution applicant, in fact, before the expiry of third implementation, that is 30th of September 23, deposited 200 crores. Deposited 200 crores. Now, State Bank of India, in fact, also contested this infusion of 200 crores. State Bank of India, in fact, contested the manner of infusion of the same because it was in contravention of the resolution plan. In this case, the successful resolution applicant infused a portion of the fund through a third party. portion of the equity capital through a third party, therefore inducting them into the resolution process as a shareholder, which was not allowed. The shareholders, in fact, are defined in the resolution plan at the time of infusion of the amount which is uh, provided in the resolution plan. The SRA also introduced a third party because the amount was contributed by a third party which was not there in the original resolution plan. So that is also a violation of resolution plan. Inducting a third party in the resolution process who was not there at the time of EOI, at the time of resolution plan, and no 29A was conducted at that time. So the infusion came from a third party, shareholder became somebody else. That means there could have been a kind of uh, arrangement of some partnership by SRA, which is not permitted. In case the acquisition has to be through a partnership, it has to be applied in the EOI through a consortium. So that name was not there in the consortium. So a third party came forward. So now this is also objected by the State Bank of India. Now, in all the three appeals filed against the implementation of the resolution plan, on 18th of January 2024, Supreme Court held that the performance bank guarantee cannot be permitted to be adjusted against first tranche payment, and therefore directed that the amount of rupees 150 crore be infused in cash on or before 31st of January 24. So this is considered to be fourth extension given by Honorable Supreme Court. First extension was given by adjudicating authority, second by ANCLAD, third by ANCLAD, fourth by Supreme Court. Now, the resolution plan could have been implemented by 31st of January 24 in case, because 200 crore has already been inducted, infused by the SRA, of course, through a third party. 150 crore additional has to be infused with up to 31st of January 24. And that order was passed on 18th of January 24. So within this 12-13 days, this 150 crore could not be deposited by the SRA. This was not deposited by SRA. In the meantime, NCLAT dismissed the company appeal filed by the State Bank of India against the order dated 13th of January 23 while holding that the SRA has fulfilled all conditions precedent and had also complied with the other terms of the resolution plan impugned. Now, NCLT extended the time limit for implementation because the Supreme Court extended it up to 31st of January 2024. Now, NCLT says that the first tranche payment obligation of 350 crores to 11th of March 24. This was the fifth extension given. This was the fifth extension given in this case, that is by ANCLAT. So then again, the date within which the creation of charge over the Dubai-based property is also to be completed. However, neither this 11th of April 2024 date could not be complied with by SRA. The charge could not be created on the Dubai-based properties. And finally, the hearing on the Supreme Court order, which was finally decided on 7th of November, in fact, came to a final conclusion. And the questions of law, which actually came and it was being discussed in the Supreme Court hearing, one, again, because in the starting also, we said that this kind of uh, questions are raised in this case. So let us again finally see, based on all these facts, where 5 implementation extensions were given, 5 questions of law were raised, 3 appeals were pending before before Supreme Court. NCLAT has actually passed 4 orders in this case. Now, in this case, whether the performance bank guarantee could have been adjusted against the first tranche payment which was to be made under the resolution plan within 180 days from the effective date in contravention of the order of the state court? That was the first question of law. Second question of law, whether non-implementation of the resolution plan by SRA necessarily leads to the consequences of liquidation as provided under section 33 subsection 3 of IBC. Whether the timely implementation of the resolution plan is also one of the objectives of the IBC. Now, when we talk about the proceedings before the Honorable Supreme Court of India, issue by issue. So the first issue raised by State Bank of India, was performance bank guarantees adjustment violates the resolution plan. The State Bank of India said that the NCLAT repeated permission to adjust performance bank guarantee of 150 crore against the consortium's first tranche payment that was contested by State Bank of India. Adjustment of this 150 contradicted the resolution plan explicitly terms which barred using performance bank guarantee as part of the SRA consideration, a prohibition clearly outlined in the RFRP. That was the contention of State Bank of India. State Bank of India also argued that the NCLAT's order violates the Supreme Court's order dated January 24, directive mandating a cash deposit of 150 crore with non-compliance triggering consequences. Then State Bank of India also contested that NCLAT misinterpretation of the resolution plan and disregarded the Supreme Court directions. Second issue raised by the State Bank of India is that the resolution plan mandates SRA to pay airport dues and parking charges upfront within 180 days to allow immediate flight operations, which with an estimated cost of rupees 240 crores in 2020, which was also capped at 475 crores. However, these dues were not paid. Therefore, since it was not paid, now these dues have now escalated to an approximately 1,100 crores. Originally, it was estimated at 240 crores. Because of all these delays, it was capped at 470 crores in the resolution plan. However, since all this was delayed, it was not paid on time in 2020. So therefore, the amount was escalated to 1,100 crore. NCLAT limited this particular amount to 25 crores in their order dated 12th of March 2024, treating them erroneously as CIRP. Accepting this would prevent payment to other creditors. Placing the burden on the COC. Thus, interpretation is flawed, warranting correction. Third, non-payment of workmen and employee dues. The resolution plan initially allotted 52 crores for the workmen and employees dues. Later, it was increased to 289 crores and then modified to 226 crores. NCLAT order dated 21st of January 2022 emphasized full payment of provident fund and gratuity as required under section 30, subsection 2, clause E. So this stance was upheld by Supreme Court. However, NCLT's subsequent order overlooked gratuity dues, focusing only on 12 crores of provident fund. So therefore, this particular argument of State Bank of India also kind of emphasized that it is not possible now that the resolution plan can be implemented. One, that the dues of DGCA has actually escalated to 1,100. The dues of workmen has actually been escalated to 226 crore, and the NCLAT has wrongly considered that only 12 crore as provident fund dues. However, the total dues of workmen and employees is 226 crore. DGCA 1,100 crore. Creditors, they were supposed to pay 350 crores. So this is something which is not easily implementable. Effective date has already been revised. Multiple times, and effective date of like 20th of May, that was also contested by, and the State Bank of India said that the SRA failed to meet payment of 350 crore, 475 crores of airport dues, which is now escalated to 1,100, 226 crores of workman dues. So therefore, no further leniency is warranted. Any non-infusion should be seen as breach of the resolution plan, and therefore the issue number 5, uh, non-fulfillment of the conditions precedent. Three critical conditions precedent under the resolution plan. SRA did not maintain a valid AOC. SRA did not maintain a valid COC. AOC, which expired on 3rd of September 2023, which was also conditional, and those conditions are also not fulfilled. Number 2, slot allotment, while initially approved, remains subject to the payment of outstanding airport dues. That was also not done. So therefore, the rehabilitation of the company without a valid air operator certificate, without slot allotment, without payment of airport dues, without payment of DGCA, and also the international tariff rights require operational readiness with a minimum of 20 aircrafts, a requirement modified by the NCLT and upheld by NCLT, again the plan terms. DGCA dues are not paid, 1,100, workers not paid, 450, 350 crore is not paid, AOC is not valid, slots are not available, international traffic rights are not available, 20 aircrafts are not maintained. So therefore, the security clearance, the fourth thing that the State Bank of India said, even the security clearance of the partner, Mr. Florian Fritsch, that is also not clear. Allegedly, involvement of money laundering, that security clearance is also not. Therefore, SBI says that it is only a case of liquidation, and it should be liquidated because it has wasted time and it is reducing the value. So the conditions of the so although the SRA, the successful resolution applicant, contested one, that the Supreme Court doesn't have the power, and Supreme Court has only the power to address questions of law. And this particular, all these appeals are primarily being challenged only on factual findings of the SRA. The performance bank guarantee towards the first, it was mentioned in the resolution plan that it will be adjusted with the first in the resolution plan. And the SRA has made significant efforts to fulfill the obligation, and SRA has deposited 200 crores. Conditions, in fact, what the conditions precedent was complied with. The AOC was available, valid up to 3rd of September 2023, and he could not implement because of the SBI filed pleadings before this Honorable Supreme Court. Therefore, this was not possible for me to implement the resolution plan, and the CIRP cost, it allows the CIRP cost, including airport dues, and finally, the positive cash balance of the corporate debtor that has to be used as CIRP cost. Finally, the contentions of successful resolution applicant was not considered acceptable Supreme Court, and the observations and the decision of Honorable Supreme Court came as: one, that the Supreme Court has extraordinary powers under Article 142 of the Constitution of India to pass a liquidation order, emphasizing that it is a necessary step to prevent further delays and to protect the interests of the shareholders. Supreme Court further said that the amount of rupees 200 crores already infused by the respondent was forfeited. It is forfeited. The appellant, State Bank of India, was allowed to encash the performance bank guarantee of 150 crores. So SRA lost 350 crores. The company is now into liquidation. The AOC, the air operator certificate, is not valid. No taxes were paid. The workmen dues were not paid. Company goes into liquidation. Now let us see what are the assets available for making payment to workmen dues. In fact, the Supreme Court, regarding performance bank guarantee adjustment, said very clearly that adjusting performance bank guarantee against first tranche payment under the resolution plan was impermissible under the terms of the resolution plan read with the regulation 36B sub-regulation 4A of CIRP regulations. The court observed that the terms within the resolution plan as approved by the COC did not provide for such an adjustment. The terms within the resolution plan as approved by the COC did not provide for such adjustment. The Supreme Court further emphasized that the performance bank guarantee is intended as a security measure, ensuring the commitment of SRA to the plan obligation. Allowing its adjustment would contradict the purpose of securing performance and undermine the contractual terms of the plan, and therefore decision was that the court directed that the performance bank guarantee be maintained and not adjusted against the upfront payment obligation. This reinforces the principle of strict adherence to the contractual terms of the resolution plan. Now let us see what court says on the timely implementation and compliance within the resolution plan. On the timely implementation, the court observes and the underscores the importance of timely compliance with the resolution plans, particularly payment schedules and statutory dues. The court remarked that the objectives of the IBC is to ensure timely resolution of the insolvency matters, avoiding prolonged delays that could erode the CD's value and prejudice creditors' interest. The reasoning which is given by the court is that delays in fulfilling obligations can lead to frustration of the IBC objective, such as asset maximization and revival of the corporate debtor. Therefore, strict compliance with timelines in the resolution plan is fundamental to the maintaining trust in the process. Decision was that the final deadline for compliance by SRA, warning that failure to meet this would result in invocation of liquidation provisions. Liquidation as a last resort, although the liquidation order was passed by Honorable Supreme Court finally said that the liquidation should not be invoked automatically due to minor delays or technical non-compliances. The court observed that the IBC's ultimate objective is resolution, not liquidation, and liquidation should be reserved for situations of genuine non-compliances or willful default. That's what is the decision. As far as the employees' dues and statutory compliances are concerned, the court says that the employees' dues, including provident fund and gratuity, must be paid in full as per statutory requirement. Even if the resolution plan proposes partial payment, non-compliance with these statutory can invalidate the resolution plans under Section 30, subsection 2, clause E of the IBC, which mandates adherence to laws for approval. That's what about the then commercial wisdom of the Committee of Creditors. Court recognized the commercial wisdom of the Committee of Creditors, but also noted that judicial oversight is necessary when COC decisions contradict statutory obligations and public policy. So now the two things: one, statutory obligations, statutory provisions, and public policy. Something which is not good for public policy, that also the NCLT has to oversee it. And judicial oversight is important. That's what it finally said. So therefore, the role of judicial oversight in the insolvency proceedings is also highlighted. The role of judicial oversight is ensuring in the insolvency proceedings adheres to the IBC objectives and statutory requirements. The court noted that it has the duty to prevent any misuse of the IBC and ensures it serves its intended purpose of rehabilitation and creditors' protection. That is also something, creation of charge and monitoring compliance. The court mandate that the charges be created over specified properties as a security measures for creditors. Additionally, it directed the creation of a monitoring mechanism to ensure compliance by SRA with the resolution plan terms. The court further held that once a resolution plan is approved by the Committee of Creditors and submitted to NCLT, it is binding and cannot be modified. NCLT's deviation from Supreme Court order mandating a cash deposit of 150 crore led to a perverse outcome disregarding the plan's term. Therefore, Supreme Court emphasized that the SRA's failure to pay first tranche of rupees 350 crore as per resolution plan, including non-payment of dues like airport dues, the violated the key clauses of the resolution plan. This non-implementation constituted a breach of resolution plan, which triggered the need for the liquidation under Section 33, subsection 3 of the IPC. The court highlighted that the SRA's failure to comply with the statutory obligation, particularly the payment of provident fund and the gratuity dues to workmen and employees, and therefore this breach also is kind of. Now, there are some shortcomings which are in fact suggested by this Honorable Supreme Court, though we have the shortcomings and also the learnings from the shortcomings and the learnings from the IPC. Uh, the entire fiasco of Jet Airways, we would see that whatever the learnings has come from this case by way of this judgment, which is dated 7th of November 2024, and by way of other three judgments which has been given in by Honorable Supreme Court, which also clarifies the rights of workmen and employees, the rights of Provident Fund Department, the gratuity dues, whether the RP is supposed to pay to workmen in case they are all on the roll, no work, no payment, whether the rule is applicable to RP or not. All this we would be dealing with in the next episode, which will be our episode number 137. Because this particular Jet Airways has given us a lot of learning. Maybe the company has gone into liquidation, but 5.5 years of the entire, we actually can, the entire book can be written on Jet Airways. So therefore, we are not stopping here. We are coming with a detailed analysis of complete learning, including the suggestions given by Honorable Supreme Court in this judgment, which is 7th of November 2024, plus various other judgments, only and only in the case of Jet Airways, that we are coming to you in the next episode on coming Saturday with the entire details. Thank you very much. It is really an enjoyable session, and we are not taking the questions today. The questions will be taken up in the next episode. And please be ready with your questions. We are coming with a detailed analysis of the entire Jet Airway fiasco and learning out of it. Thank you very much.